Good morning, and thank you for registering and joining us today for the final webinar in our 2024 series, Legal Strategies for Women Leaders. Thank you so much for your patience. We've had a little bit of technical difficulty and are unable to get our cameras to work this morning, but we wanted to go ahead and move forward with having this webinar today because we know this information is valuable and we appreciate you taking the time to be with us. I'm an attorney here at Foster Swift. My name is Amanda Dernovshek. I'm part of our firm's business and tax group. And this year we have hosted 3 other sessions of this program. The first one was with attorney Mallory Reeder, and she discussed how a business can and cannot donate funding to political campaigns. We also hosted a session with attorney Lindsay Mead, who discussed artificial intelligence and considerations that you should be thinking through if you would like to incorporate AI into your business. And then our most recent session was with attorney Gabrielle Lawrence, who discussed how to manage careers and schedules and the difficulties that arise during divorces. The key of that webinar was to consider some issues with returning to school, dividing time and responsibilities with children. And if any of those things are of interest to you or you would like to view those previous webinars, you can find them on our YouTube page. Today's session is our final session for the year, and each session is designed to provide some time for participants to ask questions, discuss legal opportunities to problem solve challenges that women leaders face. This session is being recorded, and we will email you a link following the program, along with answers to any questions that we do not have time to answer during the session. We want to be respectful of your time, so we will limit the session to 30 minutes. And today's program is informational only, and it is not legal advice. In today's discussion, attorney Kelly Reed Lucas will join us to talk about mediation, when to consider it, how it works, and similar issues. Kelly, it's always a pleasure to spend time with you, and thank you so much for taking time out of your day to chat with us about this topic. Please introduce yourself, and then we can get started.
Yes, thank you, Amanda. My pleasure to be here. This is a topic that's kind of near and dear to my heart. As someone who has, I've been practicing law since 1987 and have worked as a litigator as well as a mediator. And I can remember when mediation really broke into the forefront of conflict resolution in the state of Michigan. And it has been a highly successful process. And as a litigator, I can definitely vouch for the benefits of this process. So I'm here today to share my views and my experience in the field of mediation.
Perfect. Thank you so much. I think this is an interesting topic because almost every contract that I review has some sort of dispute resolution mechanism. And oftentimes we're advising clients that they should consider mediation before escalating a conflict straight to litigation. So let's just jump into the questions we have then. When does mediation happen, and what are the legal implications of mediation?
Well, mediation happens at any stage of a dispute. So as you've already referenced, many times there are contracts that people are parties to in which it will provide that before, if there is a dispute, that before anyone takes the step of filing litigation, that they first must try to resolve their differences through a process like mediation. Sometimes they'll have a clause that specifies for arbitration, which is a completely different process. Mediation can happen before a lawsuit, it can happen during the lawsuit, and even after a lawsuit. And there are even programs at the appellate level where the appellate courts can direct parties to mediation of any appeal. So basically, anytime there is a dispute, there is an opportunity for mediation. As far as the legal implications, mediation is a voluntary process for the most part, as far as meaning that it's not something parties may be compelled to engage in the process. The court may order parties to attend mediation, but there is no requirement that the parties must settle. And it is that feature of this process that is attractive to many litigants, because basically you're not having someone who's going to listen to you and then make a decision and enter an order and you're stuck with it. If you're not able to reach resolution, you can discontinue the process and go forward with the litigation.
Great, thank you. So the
Mm.
purpose is really just to explore opportunities for a resolution before escalating. And can you give us an overview of what the mediation process looks like and who should be involved?
Okay, well, uh, I'm going to speak more specifically with regard to court-ordered mediation.
Okay.
Um, there are various stages in which mediation can take place once a lawsuit is filed. I think most people understand that the vast majority of cases do settle. It's a question of when.
Hmm.
And there are people who advocate for early stage mediation. There are certain cases where that is totally appropriate. There are other cases where it may be beneficial to the process for the parties to engage in a form of discoveries, you have depositions, do some written interrogatories, requests to admit, and so forth, before they engage in the process. Every case, that's one thing I will say, that every case is different. And you cannot take and should not take a cookie cutter approach in saying that every case should be sent to mediation at this particular point in time. So the process is, if you are involved in a lawsuit, at some point the court is likely to enter a scheduling order. And in that scheduling order will be a timeline for mediation. And the parties are asked by the court to stipulate to the selection of a mediator. But if they are not able to agree on a mediator, the court does maintain a court-appointed list of mediators, so that if the parties are not able to pick one, a mediator they can all agree upon, the court will, by rotation through that list, select the next mediator that's up for consideration, appoint that particular person to mediate that case. Now, I've done the court appointed list in the past. I'm on various court lists around the state. It is not the ideal situation, I will admit, to having the court select your mediator. I have found that the success rate goes up immeasurably if the parties are able to agree upon who they want to take their dispute to mediate. So my preference would be if the parties can select a mediator themselves, but if they cannot, the court will appoint someone. And then the process is such that in most cases, I have found the mediation occurs after the close of discovery. And discovery, I am talking about depositions, interrogatories, document production, and so forth. That way, the parties have fleshed out their issues. They can come into mediation having kind of an understanding of what the facts are, what are the relevant issues that need to be resolved. And then they go into session with the mediator and hopefully resolve their differences. That's just a very broad view, Amanda, of the
Yeah,
process.
yeah, understood. So for anybody who hasn't been through mediation before, who is involved in this process? Is it just the parties and the mediator? Should there be an attorney there? Is an attorney required? Give me some information on that.
Yes, well, in my experience, I have typically mediated cases that are in the court system, and so most parties have legal counsel, and definitely legal counsel should be at the table with their client to advise them. I have handled cases where typically where I've seen this is in the divorce arena. Sometimes in mediations, they'll start out with counsel, they'll narrow down the issues, and at some point, for instance, let's say the parties are going to they may encounter disagreements regarding visitation, for instance. Rather than compelling attorneys to be present at future sessions, sometimes parties will say, look, we can handle this with the mediator on our own without counsel present. But that is subject to agreement. Everyone must agree to that.
Mhm.
Um, and then the mediator would report back to counsel for the parties. They can specify that no agreements would be signed as a consequence of such a session until counsel reviews and approves. But it's a way of managing legal fees in a situation like that.
Yeah. So that kind of leads me to the next question about, and it relates to fees, because obviously a mediator is taking a substantial amount of time to review materials in advance and prepare for the discussion with the parties. Who pays the mediator for their time, both preparation time and the actual mediation time?
Well, the court will typically order that the fees be divided amongst the parties. Now, sometimes you have multiple parties in the lawsuit. You could have co-defendants, and they would typically be split evenly among the parties.
Okay.
But the parties are free, as a part of settlement, they can agree to a different allocation of responsibility for the mediator's fees. I've had some where part of the issue of the settlement is the mediator's fee, and one side will agree to pay the entirety of the mediator's fee.
Okay. So let's talk a little bit about kind of the outcomes of mediation. I'm curious, does mediation or do mediators decide the case? And is what they if they make a decision, is that binding? Like what happens after mediation if a decision is or is not um, resolved?
Well, of course, the goal is to reach resolution, and the process itself is non-binding. And by that, I mean that the mediator is not a decision maker. And the role of the mediator is to facilitate communications between the parties, identify the issues that are sticking points for resolution, and flesh out options for settlement of those issues. So the mediator will work with each side, identify the issues, try to get an agreement on whatever. And by the way, mediation isn't always about the numbers. Sometimes there are other issues that need to be resolved that is more than just money. And the mediator will work to get the parties to find common ground, basically. And if it is resolved, there will be a written settlement agreement. And once that agreement is formed, written out at the mediation table, and signed, it is then binding. It is then a contract. You also have situations I can think of where this might be more than what people are wanting to hear today, but a mediator sometimes is asked if the parties aren't able to resolve their differences. Sometimes a mediator is asked to make what is called a mediator proposal. And the thought in this regard is that the mediator has had access to confidential communications with each side, kind of has a sense of where everyone is at as far as what number or what issues, how would they likely resolve. That mediator is in a unique position to assess the positions of each side and can make then a proposal for settlement. It's not binding, and it's only binding if both sides accept the mediator's proposal.
Okay. So is the mediation process confidential, or will a court know what happened at mediation?
The process is, yes, generally confidential. Myself, when I set up a mediation, I have all parties sign a mediation agreement with me that specifically states that nothing stated in the course of the mediation is admissible in court. And the idea behind this is to foster open communication between the parties, because litigation does the exact opposite.
Mhm.
But mediation, in order to facilitate open discussion and explore options for settlement, it's necessary that people feel free to speak up and not worry that anything they say at mediation may be later used against them in court. And so, yes, it is a confidential process.
Okay. So generally, statements that are made during mediation are not admissible in court. And you said it, when you're the mediator, you have the parties sign an agreement that says, you know, what we talk about is confidential. Is that a pretty common practice by mediators in our state to have that type of agreement in place?
Yes, that is my understanding. Every mediation where I have represented a party, I'm not the mediator. I've always uh, signed an agreement with the mediator that ensures confidentiality as well. It will lay out the terms of payment and various other terms that pertain to the mediation process. Yes, that's very common.
Okay, perfect. And then what happens if a case is not settled during mediation? I'm guessing it just goes back to court and continues forward with the litigation process.
That is definitely one outcome, but a really good mediator may not, just because the session has ended that day, doesn't mean the mediator is done. Some mediators are very persistent and will continue to communicate with both sides and try to encourage and move the parties towards settlement. And sometimes it works and sometimes it doesn't. But otherwise, yes, they would just move back into their litigation mode and continue where they left off with the court.
Okay, great. So my last question is really just an overview about mediation. What are the pros and the cons of this process? If someone has mediation as an option on the table, they're thinking about it to resolve some dispute that they have ongoing. What are the benefits of doing that, and what are the drawbacks of doing that?
Well, there's so many benefits. The difference, the primary difference between mediation and going to court is that the parties who are involved in the dispute have an absolute say in what the settlement will be. They are going to work in developing the terms of any settlement. If they went to court to resolve their differences, they would each present their facts, their case, their law to a judge, and the judge would make the decision for them. So generally speaking, mediation that results in settlement usually results in parties feeling much more confident in the system. They tend to have greater compliance with what, because parties have been involved in negotiating the terms of their settlement, they're more likely to honor those terms than a court imposed order or judgment against them. It also, mediation, if there is settlement, that resolves the dispute. It's done, it's over. There's no appeal, there's no worry about appeal because this has been negotiated by the parties rather than a third party imposing a decision upon them. As far as the drawbacks of mediation, there are not many because, like I've already explained, people are free to engage in the process and leave if it's not working for them, really without any consequence. But the downside is it does increase the cost if it is unsuccessful. You've added now another layer of cost to the process, the whole litigation process. But hopefully, even if a case does not settle at mediation, hopefully the issues have been isolated that are the sticking points. It helps to narrow the focus of the case. And even though parties may walk away not having a settlement in hand, usually they can go forward with the litigation in a more efficient manner than if they had not participated in the process.
Perfect. Thank you, Kelly. I appreciate that. Before we wrap up, I just wanted to give you an opportunity to, any last thoughts about your experience as a mediator, or anything that you wanted to mention that we haven't already discussed today?
Um, all I can say, well, I've mediated many different types of cases, and mediation does work for a multitude of cases. It is most effective where parties basically have some flexibility and are willing to speak and participate in the process. Where mediation struggle sometimes is if people come in with the wrong intentions. You sometimes may have a litigant that has been ordered into mediation by the court, but really hasn't bought into the process, doesn't really want to be there. That should be fleshed out pretty early by the mediator. Hopefully, the mediator is able to convince that party of the merits of this process and make it a positive experience for all involved. But I think because of the cost of litigation, and I'm speaking of not only monetary cost, financial cost, but the emotional cost of litigation, there's great appeal to parties being empowered to make their own decisions whenever they are involved in a dispute. And in my opinion, it's better to start early. A few years ago, I had a very positive experience in a domestic matter that I was involved in which the attorney on the other side was equally a fan of mediation, and she and I both agreed that we started to mediate the case very early, very, very early, right after an answer was filed with the court. And what we did was we found an experienced divorce mediator. And basically, we agreed that as we move forward through the case, anytime we ran into a snag, we would take it to the mediator. Rather than filing motions with the court, we took it to the mediator. And it was very, very successful. And we ended up having 4 sessions with the mediator over the course of a year. And a divorce that could have been very contentious if we had done it the traditional litigation route ended up being far more calm. The parties were engaged, felt they had a voice. It was a very positive experience.
Mm-hmm. That's amazing. I think that says a lot about both the attorneys involved and their willingness to do mediation and be open to that process.
Yes.
In that case too, like with domestic relation issues, there's a lot of emotions involved. And so having a voice and an opportunity to say, this is the impact of this situation on my life, and this is the settlement I want, is really powerful for the parties. And
Absolutely.
yeah, I think that's amazing. And maybe that's something for the people listening today is if you have a dispute ongoing and you are going to engage an attorney to help with this, talk with your attorney about their views on mediation and whether they're willing to work through that process. And if that seems like something that's important to you, maybe that's a helpful way to determine who would be a good fit for you in terms of representation.
Absolutely. Absolutely. Yes. In the domestic situation in particular, no one knows the children better than their parents,
Mm-hmm.
and knowing what works for their family.
Yeah.
Yeah.
Absolutely. Well, thank you, Kelly, for your
You're
expertise
welcome.
and your willingness to discuss this topic with us today. I also want to thank all of our attendees. Thank you for sticking with us through our technical issues. As
Yes.
mentioned before, we will be sending a link of the recording of today's session as well as a short survey. We value your feedback and we look forward to providing you with valuable programming in the future. If you have ideas for topics that you would like for us to present on, please include that feedback in the chat feature or in our survey, whatever is easiest for you. And if there are topics in particular that you want to hear about, please reach out. Even if it's not a webinar, you can absolutely contact Kelly or myself. We'd be happy to talk with you. And as we wrap up, the screen should be showing a list of our firm's women attorneys, their areas of practice, and their contact information. This will also be included in the link if you have a question on today's topics or other questions. Kelly, I think you would agree here that as women professionals, we really value the opportunity to network and to do business with other women leaders. So
Yes.
consider this an open invitation to reach out and connect with any of us here at Foster Swift. Thank you, everyone, and have a lovely day.